Welcome back. This is the module on Court Interpreter Scope of Practice, a short presentation on the importance of confining yourself to the role of interpretation. According to Holly Michelson, Rosanne Dueñas-Gonzalez, and Graciela Vázquez in their seminal book, Fundamentals of Court Interpretation, an interpreter is a bilingual person who has the duty to act as the medium between the court and the limited or non-English speaking person. This is from 2012. Interesting because in this quote, I think we're missing an important part. Not a bilingual person, but a trained professional, in my humble opinion. What is the role of the court interpreter? Well, we are part of the main players in the court. We have, of course, the judge, the jury, the courtroom clerk, the court reporter, the bailiffs, marshals, or sheriffs, whatever they call them in your jurisdiction, the attorneys, defense and prosecution, and, of course, the interpreter. In your presentation, you're going to get the handouts with these players. It's a very good idea to start researching how would you say all those words in your language of expertise. So what is the role of the interpreter? When you're interpreting in a court of law, the legal status of a court interpreter in most jurisdictions is one of the officers of the court. You have obligations. You're also, interestingly enough, considered a court expert because your ability to interpret from one language to another, and the fact that you mediate those two languages, and the fact that what the interpreter says in English on the consecutive mode becomes the record, that gives you the responsibility of being accurate and complete. Which is why Canon 1 is so important for the scope of your practice. Canon 1 of the Code of Ethics, and we're referring here not necessarily to the Code of Professional Responsibility of Ohio, but the Code of Ethics proposed by the National Center for State Courts in their famous 10 Canons of the Code of Ethics. What we do know is the Code of Professional Responsibility for interpreters in Ohio is based on these same canons of the Code of Ethics. Canon 1 specifically says that the interpreter shall render a complete and accurate interpretation. The interpreter shall render a complete and accurate interpretation. Complete means that within the scope of your practice, you have to interpret everything, including the registered use in the source language. If it was slang, you should interpret with slang. If it's high registered, high registered. You have to get very critically involved in the nuances of each word that you use. It's not the same to slap than to punch. It's not the same to run than to walk swiftly. How about obscenities? The interpreter has an obligation to completely interpret, including obscenities. If somebody uses an invective or a bad word, if you may, the interpreter must interpret to the best of his or her ability with the closest legal equivalent. Let me remind you, this closest legal equivalent, it's also a term introduced by Holly Michelson, and it implies that sometimes we don't have a word that defines another word in legal terms. Sometimes we have to use two words. For instance, it's very well known in our profession that arraignment is hard to interpret in many languages with one word. So many languages, solution, legal equivalent, is to interpret it as a formal reading of charges. In the case of obscenities, you might not have the exact word, or in each language the word might not have the same impact, but the obscenity has to be transmitted with the same impact. Therefore, find the closest equivalent. Repetitions. If a person repeats themselves, you repeat it to an interpretation. But if an attorney asks something like, "Can you repeat that?" always keep in mind that you are not being asked to repeat it as the interpreter. As the interpreter, what you should do is turn around and interpret for the individual so they can repeat whatever they have to repeat. Self-corrections, don't eliminate them. You have to interpret completely. If the person says, I went there on Tuesday. No, I'm sorry. It was Wednesday. You don't interpret as, I went there Wednesday, because there was a self-correction, and that might be important, or as a matter of fact, it is important for the triers of fact. They can decide whatever psychological reasons why the person corrected him or herself. According to Interpreter's Code of Ethics, again, in the Canon 1, says the interpreter shall render a complete and accurate interpretation, which means when we do with accuracy, you can't embellish. Refrain from adding politeness to some of the expressions that you might hear in court. It's common to hear for attorneys and judges and clerks say things like, spell your name for the record. But us interpreters, we want to be very polite and sometimes include this famous, please spell your name for the record. Keep in mind, you're losing accuracy if you're embellishing. Clarifications are necessary for interpreters to interpret accurately. If you're not sure about the meaning of something that you must interpret, you must ask for clarification. Never guess, never take an educated guess. If it's ambiguous, and a word that immediately comes to mind for me is children, because if the context is not enough for you to know if the children are either my children, are adults, or real children, minors, you might have to clarify, because in English sometimes it is confused. I have 4 children, and you know that the person is older, and we are not sure if these children are adults or not, and that might be necessary for the other language. Editing. You don't edit anything, either for or against the person that you're interpreting for. You don't leave out bad words. You don't think, well, that's going to be damaging for this poor person, so I might as well not say it. You're not editing. You have to be accurate. If, following Canon 1, you were confronted with this situation, while interpreting simultaneously during a trial, the judge and the defense attorney are discussing an objection, the defense attorney tells you, the interpreter, you don't need to interpret that. What do you do as a court interpreter? What should you do? Think about it for a second. You're interpreting simultaneously. Attorney and judge are having this discussion. She or he tells you, you don't have to interpret that. What should you do? Well, according to Canon 1, because you have to interpret completely, you, the interpreter, should continue interpreting simultaneously, as you were doing before. You actually have to make sure you do not leave out the defense attorney's instruction directed to you, because if the person spoke English, they would have heard that. To recap, in order to render a complete and accurate interpretation, you, the interpreter, must interpret everything you hear from one language into another. Now let's talk about another canon of the Code of Ethics, Canon 7. Canon 7 says the interpreter shall confine herself to the role of interpreting. I love this. Very succinct, very clear. What is the job of the interpreter? To interpret, to be a conduit, to mediate between two people that cannot speak the same language, help them overcome the language barrier. The court interpreters shall, according to Canon 7, confine themselves to the role of the interpreter. That means that you should not do anything outside that confine, including giving legal advice. We're not attorneys. Now, make sure that giving legal advice doesn't trick you, because sometimes we feel, well, if I just say, most people don't do this, I'm not really giving advice. Oh, yeah, you are. Giving legal advice includes asking people to do something, but also telling them, most people don't do this. For instance, the person says, should I get an attorney? Most people for traffic cases, they don't get. That is giving legal advice. Canon 7 says, that's not interpreting, you're outside the scope. Doing clerical work, you're not there to fill out their forms, to accompany them. Cultural expertise. Avoid becoming the cultural expert. What does that mean, Madam Interpreter, if the person blinks twice? Is that a cultural issue? Remember, if you're outside of interpreting, you're outside the scope of your practice. You need 2 to tango. You need 3 to interpret. If there's only 2 people, you're having a conversation. You should not give instructions to parties on your own. I have seen this more than once, that attorneys use interpreters kind of like messengers. Go tell the defendant there's a plea agreement that if he accepts this, it's going to be 3 years in prison. That is not interpreting, and therefore is outside the scope of your practice. Let's assume that the prosecution and the defense attorney just negotiated a new plea agreement, which you just interpreted for the LEP or NES. During a recess, the defense attorney hands you the written plea agreement and asks you to sight translate it for their client and make sure they understand it. Think for a second. Is that interpreting? The sight translation part it is, but what about this make sure they understand it? Meanwhile, the defense attorney will go somewhere else to take care of another matter. What should you do? Well, what you should do is remember the maxim. If you're not interpreting, you're outside the scope. So you, the court interpreter, should advise the defense attorney you are glad to sight translate the plea agreement for their LEP client. However, as per Canon 7 of the Court Interpreter's Code of Ethics, you may not take any additional actions to ensure the LEP's understanding of the document, since that would require you to go outside of your professional scope of practice. Additionally, you must advise the attorney it's considered best practice to have them present while you render your sight translation, especially for the purpose of them clarifying, explaining, and answering questions from the LEP regarding the documents, things that of course you're not allowed to do. Believe me, that has happened to me more than once. The attorney saying, just go ahead and read it and I'll come back later. And it never fails. I have to admit, when I first started in this business, I thought it was okay. And because I thought it was okay, I would do it. And then I wasn't done with the first 2 sentences when I would immediately have people ask, so what does that mean? So do I sign here? Will you explain it to me? I don't know what it means. Please help me. It is not a good idea to sight translate documents for LEPs or NESs without the presence of the attorney. This should make it very clear. And I always say, it's so simple. Are you interpreting? If the answer is no, you're outside the scope. This is the end of the module.